Hi, very good morning. This is again a Supreme Court judgment under the Negotiable Instruments Act, HDFC Bank versus State of Maharashtra. There were two issues before the Supreme Court. One is whether the words of Section 141 of the Negotiable Instruments Act, whether they are mantra to be repeated as such in the complaint. That is the first question. Second question before the Supreme Court was whether it is necessary to cover the role of each director or the role of each director in the complaint, because only if he is in charge of and responsible for the company, for the day-to-day affairs of the company, he can be brought within the section 141. So is it necessary to cover the role of each director in the complaint? These were the two issues before the Supreme Court. Facts of the case, simply put, there were three directors in a company. They approached HDFC for a credit facility for working capital requirement. On failure of the company to repay, account was classified as NPA. Legal notice was issued, but that was returned as unclaimed. Then they went and filed a complaint before the court, trial court, against the company and the three directors. The three directors approached the High Court under Section 482. High Court quashed it, saying that proper averments are not made in the complaint, hence it quashed. Uh, Most of the averments were reproduced by the Supreme Court, but I am not repeating it because, according to me, otherwise you can read the judgment, entire judgment itself. The important averments are: one, accused were directors of the company and are responsible for day-to-day affairs, management, and working of the company. This averment was made. Then, in the complaint for attracting vicarious liability of directors, HDFC averred that the accused were uh, negotiating, they deposited documents, they signed the documents, etc. So, broadly put, they said you are responsible for the day to day affairs of the company. Secondly, you are responsible for negotiations, signing, producing documents, signing the documents, etc. Broadly, these two. But Bombay High Court did not agree with this and then they quashed the complaint. Supreme Court noted Section 141 of the Negotiable Instruments Act, which employs the words was in charge of, that is important, in charge of, and was responsible to the company for the conduct of the business of the company. So in the complaint, they did not say in charge of. Other than that, everything they have said. So Supreme Court noted the complaint used the phrase responsible for its day-to-day affairs, management and working of the company. But going by the dictionary meaning, it is the same as in charge of and was responsible to the company for the conduct of the business of the company. So just because they did not put in charge of, that will not matter much. That is what Supreme Court says. The contention of the counsel was that the actual words mentioned in section 141 in the same form must be employed in the complaint for the complaint to be sustained. So the counsel said no, in charge of and responsible for the conduct of affairs of the company must be there. Otherwise, it cannot be sustained. Supreme Court noted down various judgments in this connection. So the following principles were laid down. These five important principles are important. So I am giving the five principles laid down by the Supreme Court in a short manner. One, the condition mentioned in section 141 must be satisfied. The person who is sought to be made vicariously liable had a role to play in the incriminating act, and further, that person should know what is attributed to him. That is point number one. Point number two, the role of a director is a question of fact. There is no universal rule that director of a company is in charge of its everyday affairs. That is rule number two. Principle number two. Three, not every person connected with the company is made liable under section 141. Liability is cast on persons who may have something to do with the transaction complained of. A person who is in charge of and responsible for conduct of the business of a company would naturally know why the check in question was issued and why it got dishonored. That is three. So, person director who is in charge of will know why the check was issued, why it was dishonored. So, third principle. Fourth principle. Every person connected with the company shall not fall within the ambit of the provision. It is only those persons who were in charge of and responsible for the conduct of the business of the company at the time of commission of an offense who will be liable for criminal action. So, not all the employees who are there, all key managerial persons and directors, they are all not responsible. Only those persons who, at the time of commission of offense, knows everything, why this check was issued, why it was dishonored, that fellow alone is responsible. 5. Complaint must disclose necessary facts. So, based on this, Supreme Court rejected the contention that parroting of the words of section 141 is not required to sustain a complaint. Unnecessarily, you need not have to exactly say in charge of, and no, complaint has to be read as a whole. Supreme Court held that the repetition of the exact words of the section in the same order, like a mantra or a magic incantation, is not the mandate of the law. What is mandated is that complaint should spell out that the accused falls within the parameters of section 141 of the Negotiable Instruments Act. Only then vicarious liability can be inferred against the said accused. To proceed to trial, substance is more important than the form, Supreme Court said. Then another contention was advanced. The other contention was specific role of each director or the employee should be stated in the complaint. Otherwise, complaint cannot be sustained. Otherwise, it should be dismissed. Complaint should be dismissed. Supreme Court rejected this contention also, stating that the administrative role of each director would be within the special knowledge of the company or the director of the firm, and it is for them to establish that they were not in charge of the affairs of the company. Supreme Court looked at various precedents of the Supreme Court in this connection. So, number of judgments have been seen. Let us not get into each judgment and say what it has said. The final crux is there is no obligation on the complainant to plead in the complaint as to the matters within the special knowledge of the company or the directors, or to state the specific role attributed to them in the company. That is not, the complainant need not state what is the specific role. If he says they were in charge of everyday affairs of the company and was responsible for the conduct of the business, that itself is enough. That's because he will not know how he will know what the role played by the director. It is within the special knowledge of the director and the company. That is what Supreme Court says. Supreme Court set aside the judgment of Bombay High Court and directed the directors to face the trial. My comments, as usual, I don't end any judgment without my comments. In this case, the husband, wife, and daughter are the directors of the company. I personally feel, so I cannot generalize certain things, but what I feel is many a times husbands dragging their innocent wife or wives, we cannot say, or daughters in the business is, I think it's a stupid idea, because they think that courts will be lenient on ladies. because they make them sign the check. In fact, I handled one case. Uh, I saw the wife crying. Then I could not handle that case actually. I'm not. I was. I could not conduct the case. That is one of the reasons. So you have to see the wife crying in the court. That is the trial court. That is another horrible thing. The second thing is always taking a loan is easy. Repaying it is difficult. The saying is try to be alone and not lonely. It's a wonderful saying. So think on this. Thank you very much. Have a great day.